He violated the Fourth Amendment, but he didn't realize he was and didn't intend to. So we let it in.
What is a Scalia probable cause affidavit? First, I will give you an example of one, then I will tell you what it is. Your affiant, a detective at White Valley Police, hereby swears the following. This afternoon, I was walking past Steve Murray's car when I received a message from God. God told me the car contains contraband. Your affiant swears in good faith he has no obvious reason to doubt this message. State law requires that I say, I believe there is probably a crime, before searching a car. There is no law which says your affiant can lie to obtain search warrants. White Valley Police has an internal affairs division. For this reason, your affiant requests this honorable court issue a warrant to search Steve Murray's car. This Scalia affidavit has 4 components. 1. It has a government employee producing fake reasons which he claims cause him to believe it is probable there is a crime. 2. There is no claim that he doesn't actually believe the reasons or fake the reasons to search the car for some other reason. 3. There is no law that says he can fake reasons to search the car or directs him to. 4. Local voters or government can penalize him for faking reasons. The original Fourth Amendment says, personal security shall not be violated without probable cause and a hearing to confirm that probable cause. Like the Sixth Amendment right to a jury trial, the Fourth Amendment requires a process roadblock, where a judge examines the reasons himself and double-checks whether he also thinks there is reason to believe there is a crime. The key is that the cop has to swear the facts to a judge, and the judge has to then also himself believe, based on the facts, that there is probably a crime. The judge needs to himself believe the reasons are valid and independently conclude that there is probably a crime. The judge can say, a message from God is not a real reason, based on which I believe there is a crime. But Justice Scalia reinterpreted the Fourth Amendment to be more like the First Amendment. Shall make no law violating security without probable cause. Scalia removed the hearing examining whether there is really reason to believe there is a crime, where the judge must himself confirm the reasons are real so that the judge himself also thinks it is probable there is a crime. Scalia replaced it with a hearing which instead examines other things. A Scalia Fourth Amendment hearing instead examines, did the cop claim to himself believe there was a crime, regardless of whether the judge thinks it was an error? Did the cop at least fake or produce some reasons that could have led him to this belief? Regardless of whether the judge finds the reasons are valid or make a crime likely in the judge's own opinion, does local law direct police to violate security without even needing reasons that make a crime seem likely? Can police be penalized for violating security without claiming to have a reason, or for lying about the reason? So a Scalia hearing does not examine the case-specific reasons for the specific search. It instead examines state law. So as long as state law does not call for cops to lie and fake reasons, as long as the cop had to lie and break the law to search your car without real reasons to believe there was a crime, then the hearing allows your security to be violated without the hearing judge thinking there were real valid reasons that made it probable there was a crime. So a Scalia judge does not ask, were there real reasons which I think make it probable there is a crime? The Scalia judge asks, did local law require the cop to claim he thought there was a crime? A Scalia affidavit might even be simpler. Your affiant swears he believes there is likely a crime. State law requires that I say I believe there is probably a crime before searching a car. White Valley Police has an internal affairs division. Since the hearing never examines the reasons, only whether the law allows him to lie, the cop does not even need to include the reasons in his affidavit. We can just assume he had reasons. Of course, he also does not need to mention state law in the affidavit for it to be examined at hearing. And we don't need a hearing in each case to examine state law. So all we need is an affidavit that says, I believe there is probably a crime. And then check occasionally in some other venue, not this specific case, whether state law requires cops say they believe there is a crime and allows them to be penalized. Your affiant swears he believes there is likely a crime. Does state law say cops can search a car without saying they believe there is probably a crime? Does the average police department usually claim to use an internal affairs division? So Scalia has reduced the Fourth Amendment hearing to a periodic check on the general laws and management habits of police in no state in particular.